Good afternoon, everyone. My name's Edward Denehan, and I welcome you to the second in a series of 3 webinars I've put together on the operation of Part 2 of the Landlord and Tenant Act 1954. As is my way with these webinars, I will speak for an hour on the subject matter of today's paper, and I've also produced 2 full papers which will be circulated to delegates in the next few days. You'll receive an email from Chambers with a link to take you to the papers and other supporting material that I produced for today's webinar. What I would ask you to do during the course of the webinar is to keep your microphones on mute. We've had some amusing, albeit distracting noises during 1 or 2 of the webinars, and it's best if that doesn't happen for reasons that are obvious. I don't take questions either during or at the end of the webinar. That just doesn't work, it seems to me, in this remote way of presenting material. But if delegates have a general question they would like to ask me, that when I mean general, not a specific case, then please feel free to email me, and I'll try and get back to you. Well, I will get back to you with my views, if not my answers. Today's paper concerns the practice and procedure of Part 2 of the 1954 Act, and what I've done is divided the subject into 2 different types of case. One where there's an opposed application for a new tenancy, and the second is an unopposed application for a new tenancy. The first paper I speak to deals with opposed applications, and the second deals with unopposed applications. In order to make such a dry subject as practice and procedure a little bit more palatable, I've devised a very unsophisticated hypothetical case, which I will use throughout the papers and will speak to on occasions during this afternoon's hour together. And the hypothetical case involves a landlord called Landlord Limited, a tenant called Tenant Limited. I wasn't going to try and impress with my literary allusions, but just go straight to it. Concerning the 2nd and 3rd floors of an office building called Grade A House. It's occupied by Tenant Limited for the business of its life sciences. Don't know what that means. And the lease is dated the 24th of June, and it's a fixed term which expires on the 24th of March 2024. It's common ground between Landlord Limited and Tenant Limited that this is a tenancy, or the tenancy created by this lease is one to which Part 2 of the 1954 Act applies. We pick it up on today's date. That's the 17th of April 2023, and as of today's date, the term created by the lease is extant. It doesn't expire until March of next year. Accordingly, as of this date, the Landlord Limited can't bring the tenancy created by the lease to a premature end unless it has grounds to do so by, for example, forfeiting, and elects to do so. But putting that aside, Landlord Limited is stuck with Tenant Limited at least until the 24th of March 2024. That doesn't mean the landlord has to sit on its hands today or in the next few weeks. It can take steps to determine the tenancy. First question that arises, should the landlord initiate the renewal procedure? What I say is that ultimately it's a commercial decision for the landlord. If, as in our hypothetical case, the landlord wishes to oppose any application for a new tenancy, well, then clearly it will want to bring the tenancy to an end in order to obtain VP of the demised premises. The timing of that might be significant, depending upon the grounds of opposition that the landlord seeks to rely upon, and we'll come back to that in a minute. But ultimately, it's a commercial decision. In a classic case, it will be in the landlord's interest if the premises are over-rented to not oppose an application for a new tenancy or not initiate the procedure at all. And similarly with the commercial decision for the tenant, if the tenant wants to take the initiative. If nothing is done, come the 24th of March 2024, the current tenancy will continue in perpetuity unless and until it is determined in accordance with the provisions of the Act. So landlord wants to decide what he wants to do or what wants to do. First part of the procedure that's available to the landlord is to serve a notice in the prescribed form on the tenant under Section 40 to obtain certain information. Section 40 places a duty upon the tenant to provide a reversioner, who may not be the immediate landlord, with certain information in writing if a notice in the prescribed form is served on the tenant, requiring the tenant to do so. I explain in the note more fully what the prescribed form of notice must contain, but essentially it's two sets of information that the landlord can request under Section 40. The first is concerning the tenant's own occupation. It wants to know if the tenant is in occupation of the demised premises or some part of it for the purposes of a business carried on by it. And also the second category is whether there's been a subtenancy granted of the demised premises or any part of it, and whether those premises sublet or occupied by a business tenant, the term, if it's been determinable, what the rent is, who is the subtenant, and so on and so forth. That sort of information, including whether a Section 25 notice or Section 26 request has been served in relation to the subtenancy. The duty imposed by Section 40 is one that requires the tenant to provide the information within a period of 1 month. And then there's a continuing duty on the tenant for a period of 6 months that if it comes to the tenant's knowledge that the information that was given in response to the Section 40 notice changes, if somebody moves out, for example, then they have to update the landlord with that new information. Section 40 big A of the Act concerns what are called transfer cases, and essentially what that means is when if in a case the landlord's interest changes or the tenant interest changes, there's been an assignment or so on and so forth, there's special provision dealing with what those transfer cases, who it is who's got to update the landlord with the information sought. I won't go into the details orally today. The details are set out in the notes. A tenant who fails to comply with the duty under Section 40 may be the subject of civil proceedings for breach of statutory duty, and one can obtain an order requiring the tenant to provide the information, and the court can award damages for any loss that the landlord might suffer as a result of the tenant's failure to respond. I can't think in many cases that there would be any great loss or damage, but one never knows. Wasted costs, for example, I speculate. In our hypothetical case, we'll assume that Landlord Limited is fully aware of the position in Grade A house, and it knows that Tenant Limited is in occupation of both those floors in the building for the purposes of its business, and therefore the tenancy created by the lease is within the 54 Act, and prima facie Tenant Limited is in a position to benefit from the protection that Part 2 of the 54 Act provides. So what can the landlord do in order to get the ball rolling, if you will? The most obvious step for the landlord to take is to serve a notice under Section 25 of the Act. That's one of the means by which a tenancy to which the 54 Act applies, or Part 2 of the 54 Act applies, can be determined. And it is a notice in the prescribed form, and it must specify a date on which the current tenancy has come to an end. And the notice must be given not more than 12 nor less than 6 months before the date of termination specified therein. As we have here a fixed term tenancy, which expires on the 24th of March 2024, the earliest date of termination that can be specified in the Section 25 notice served by Landlord Limited in our hypothetical case is the 24th of March 2024. It doesn't have to be, it could be later, and there might be good reasons why the landlord would want to delay somewhat the renewal procedure, but it simply can't be earlier than that date. So on the 17th of April today, there's less than a year to go, but more than 6 months. So Landlord Limited could serve its Section 25 notice on Tenant Limited today or some other day this week, or indeed any days down to a period 6 months before the 24th of March 2024. It's expressly provided in Section 25 that when a landlord is opposing the grant of a new tenancy, it must state that it is and specify one or more of the grounds in Section 30, subsection 1, upon which the landlord will seek to rely to oppose the application. The prescribed form is a tick box and cross through multi-choice exercise. So what needs to be specified in it is self-evident, I would suggest, from the form itself. And there's paragraphs 3 and 4 of the prescribed form that deal with the information that's on the screen at the moment. So I will not oppose the application for a new tenancy, and I rely upon the following grounds: none, or 1 through A through to G. The third webinar in this series, which I will be presenting on the 5th of May 2023 at 3 p.m. Get your tickets now. I will be addressing the grounds of opposition that a landlord can rely upon in full detail. Just to remind delegates this afternoon that they are, as I say, A through G, and ground A is failure to maintain the holding, and therefore the tenant ought not to be granted a new tenancy. Ground B is that due to persistent delay in paying rent, the tenant ought not to be granted a new tenancy. Ground C is that the tenant ought not to be granted a new tenancy in view of other substantial breaches of its obligations under the tenancy, or for any reason connected with the management and use of the holding by the tenant. Ground D is that the landlord is offered and is willing to provide or secure reasonable alternative accommodation for the tenant. Ground E is a little bit more complicated. That arises where there has been a subletting of part of the property comprising a superior property, and the landlords would get a better rent if it was able to let them all as one. Very rarely arises in my experience. 31F is the termination of the current tenancy. The landlord intends to demolish or reconstruct the premises comprising the whole holding or a substantial part. And G is on the current termination of the current tenancy. The landlord intends to occupy the holding for the purposes of a business carried on by it or as its residence. Well, that will never happen in our case because a limited company can't reside anywhere. Going off tangent slightly for a moment, because although I'm dealing with a hypothetical case, I want the notes to be full. And of course, it's not just the landlord who can take the initiative. Section 26 of the Act allows a tenant to make an application for a new tenancy. And as I say on the screen, Section 43 allows the tenant to obtain information from the landlord, much the same as the information that I've touched upon already, and the same duties apply. I won't bore you with any more of that. So the tenant can make a request for a new tenancy by serving a notice in the prescribed form on the landlord, and it's only tenants who have fixed term tenancy exceeding a year that can make a Section 26 request. Periodic tenants of business premises can't. My practice is I can't ever remember dealing with a periodic business tenancy case, but there it is. So it's only fixed term tenants who can apply or make a request under section 26. The date of termination specified in the notice, section 26 request, again, not less than 6 nor more than 12 months, and not earlier than the date that the lease would determine by a fluxion of time at common law. So the earliest date of termination the tenant could specify in a section 26 request would be the 24th of March 2024. Section 26(4) describes what happens if we have a battle of notices, section 25 and section 26 request. Putting it simply, the first in time prevails. Who goes first? There are any number of reasons why the landlord or the tenant might want to take a grip of the procedure and start the ball rolling, or postpone it somewhat. In my notes, I've reproduced some of the reasons that are relevant to the decision taken from the work Renewal of Business Tenancies, which is a very useful monograph on the 54 Act. I won't read them out here, all of them anyway. Most obviously, it allows the person serving the notice or making the request, the landlord or the tenant, to have control over the date of termination. Might be reasons for financial reasons why the landlord might want the tenancy to continue. Similarly, the tenant might want to bring the tenancy to an end as soon as possible if they're over rented, and so on and so forth. So again, I can allow the delegates to read those at their leisure. In our case, we'll assume that the landlord solicitors are keen to get going, and they serve a section 25 notice on the 21st of April, that's the end of this week, a Friday at 6 o'clock, just to make life difficult, and specify the 24th of March 2024 as the date of termination, and relying upon the ground in 31F, namely an intention to demolish and reconstruct the holding or a substantial part thereof, and they need to know, they need to have possession in order to reasonably do that. Section 66 of the 1954 Act, which is not in section, it's not in part 2 at all, provides as to notices, and it applies section 23 of the Landlord and Tenant Act 1927 to notices served or given under the 1954 Act, and that of course includes part 2, the act that the part we are concerned with. Section 23 of the 1927 Act, in bullet form, essentially provides that the notice can be served by personal service, leaving it at the last known place of abode, and a place of business can be a last known place of abode, posting it in a registered letter or recorded delivery to the last known place of abode. These provisions are not mandatory. You can serve the notice however you like if you're a landlord or a tenant, but the advantage of relying upon section 23 of the 1927 Act is that if these means are employed, there is good service irrespective of whether the tenant has received the notice or not. So in our case, the landlord serves a notice in one of these means. So what's the response? Well, in the hypothetical case, there's been a section 25 notice. So there's nothing that the tenant need do in response, save for making an application to the court. And we'll talk about that in a second. Prior to June 2004, tenants had to serve a counter notice under section 20, subsection 5. And if they didn't, then that was game over for the tenant, and the tenant would tenancy would come to an end at the date specified in the section 25 notice. That requirement was eliminated by the 2003 order. It was thought, quite rightly, that it was a trap for tenants who would simply forget to do it or negotiate with their landlords because the landlord wasn't opposing and just never get round to do it. If the tenant limited had taken the initiative in our case and served a section 26 request, if landlord limited, as it does, wish to oppose the application under section 31F or one of the other grounds, or one or more of those grounds, it would have to serve a counter notice within 2 months, specifying that it wished to it would oppose an application and would rely upon section 31F. So again, if that hadn't happened, if that doesn't happen, then the landlord can't oppose the application for a new tenancy. Applications to the court, getting more into the meat of it now. There are 3 types of application that can be made. An application under section 24(1) by the landlord, an application under section 24(1) by the tenant, or an application by the landlord under section 29(2). The application under 24(1) is an application for the grant of a new tenancy. You might think, well, why would a landlord who wants to oppose make such an application? And that would be a good question, because there's no need to do that, because the landlord can now go under section 29(2) for an order terminating the current tenancy. So in a case like ours, the hypothetical case, the tenant could get its application to the court in under section 24(1), or the landlord, which it does in our hypothetical case, applies under section 29(2). Now, the important point that arises here is that that application must be made before the end of the statutory period. And the statutory period is the period that ends on the date of termination specified in the section 25 notice or the section 26(6) counter notice served by the landlord. So what that means is, in either case, in our case, is that the application to the court under section 24(1) or 29(2) would have to be made before the 24th of March 2024, and the court has no jurisdiction to extend that time within which the application must be made. As I say, since June 2004, so long ago, a landlord can apply to the court under section 29(2), and that allows the court to grapple with, in the first instance, the ground of opposition that the landlord seeks to rely upon. If the landlord makes out its ground of opposition, that's the end of the game, and the current tenancy will come to an end 3 months and 21 days after the court has decided that the tenant is not entitled to a new tenancy. That's the consequence of the application of section 64 of the Act. The 3 months is a period after the application is finally disposed of, and that includes any time for appealing. So assuming there's no appeal, that would be 3 months and 21 days. If the landlord fails to make out its ground of opposition, the court will make an order for the grant of a new tenancy, and self-evidently it won't be on that day, because the court will decide the issue of the landlord's ground of opposition, which is a trial in itself, but neither party will have armed themselves in a position to argue about the terms of a new tenancy. So in practical sense, what that means, it will be hived off for a trial of those matters, which may or may not be substantial. A very useful provision in section 29(b) is that the landlord and the tenant can, by agreement in writing, extend the statutory period, provided they do it before the statutory period expires, and they can continue extending it by agreement in perpetuity before the expiration of the period specified in the current agreement. So that can be a useful time made available to the parties, particularly in an unopposed case where there may be useful negotiations for the grant of a new tenancy, on the terms of the new tenancy, not so much in the context of an opposed application. Indeed, when a landlord is opposing on a 31F, the tenant might take the view it's in its interest to get this thing before the court sooner rather than later, because the landlord might not have all its ducks in a row in order to be able to satisfy the court that the statutory ground is made out. Pausing there, there's a jurisdiction of the court under section 24 for either the landlord or the tenant to apply to the court to fix an interim rent. And an interim rent is the rent the tenant is obliged to pay whilst the current tenancy continues under section 24(1). In our case, the contractual term would come to an end on the 24th of March 2024, but because of the procedures that we're now boring ourselves with, the tenancy will be continuing after that date under section 24(1). In 1969, the Act was amended to allow a landlord to apply for an interim rent because in times of property inflation was rampant. It was in the tenant's interest to delay, and therefore it was thought to work unfairly for landlords who now can apply to have an interim rent fixed. In 2003, it was thought that worked unfairly with tenants, because if the premises were over rented, the landlord wouldn't make an application for an interim rent. It would just sit on its hands. So now tenants and landlords can both apply for the determination of an interim rent. And you can make that application at any time up to 6 months after the termination of the current tenancy. So even if a tenant has to leave because the landlord is successfully opposed, the landlord has 6 months after the current tenancy terminates to make an application. And even if the tenant gets a new tenancy, the current tenancy will determine immediately before the new tenancy starts, and there's still a 6 month period after that for either the landlord or the tenant to apply. The date from which the interim rent payable is the earliest date that could have been specified in the section 25 notice or the section 26 request. At the date the landlord or the tenant, as the case may be, served the section 25 notice or made the section 26 request. So our notice was served on the 21st of April. The earliest date that could be specified in the section 25 notice to determine the tenancy was the 24th of March. So that means the interim rent in our case, if an application is made, would be payable from the 24th of March 2024 until the tenant vacates, and if it was an unopposed case, until the new tenancy commenced. The 2004 amendments made by the 2003 order introduced various formula for the calculation of an interim rent, which not confused, but complicated the matter somewhat. In an opposed application, the interim rent will be determined under section 24 big D, and it's the rent which is reasonable for the tenant to pay while tenancy continues under section 24. And in determining that, the court must have regard to the terms of the current tenancy and the rent payable under the subtenancy of any part. And apart from that, section 34 applies. Section 34 is a section which makes provision for the agreement or determination of the new rent under a tenancy. So essentially it's an open market rent disregarding certain tenants' improvements, but in the context of interim rents, it's on the basis of a tenancy from year to year of the whole of the premises demised by the current tenancy. Often very difficult to get comparables for a yearly tenant of business premises, but there it is. The requirement that the court have regard to the current rent is interpreted as meaning there's a bit of a cushion. So if the market rents have gone through the roof, the court will discount that, usually 20%, 25%, it varies, to reflect the fact that the tenant is facing a great hike. Nothing is said in the Act or in the rules about payments of interim rent. the reality of it is that once the interim rent is paid, determined, it becomes payable. And by that date, there might be as it were, in inverted commas, arrears of interim rent. So there's often a substantial lump sum for the tenant to pay. I did one 54 Act case many years ago involving 50,000 square feet of office accommodation at Orange Street, just behind the National Gallery extension. And the interim rent that was an issue was over 7 figures. So it was a government department who occupied the building, and I was for the landlord, a bank, Middle Eastern bank. So there was plenty of money splashing around, but there it is. The court has a discretion whether or not to order an interim rent. I've never done a case where the court has refused to order an interim rent as a matter of discretion, and I'm struggling to think of any circumstances when it would do so. Should mention about compensation. There's 2 circumstances in which compensation is payable under Part 2. One under Section 37 and 37, second under Section 37A. 37 compensation is when the tenant is not granted a new tenancy because the landlord relies on successfully relies on 31 E, F, and G. The tenant, if the tenant's is refused a new tenancy on those grounds, it's entitled to compensation, and the compensation is a sum equal to once the rateable value of the holding or twice the rateable value of the holding. You get the double rate if the if the premises have been occupied for business purposes for the period of 14 years immediately ending on the date of termination of the current tenancy, and that is the date specified in the Section 25 notice or the 26 request, not the actual date that the tenancy comes to an end by operation of Section 64. So if you've got a occupation for business purposes, for that business for 14 years, then you get double rateable value. The business doesn't have to be carried on by the tenant, who is the tenant at the date when the compensation is payable. So if you like, a tenant who takes over a business that's been carried on the premises for that time gets the double compensation. There's enormously complicated rules and procedures about how one determines what the rateable value is. I needn't trouble you with that, but I have set it all out in the notes. The second basis upon which compensation is payable is under Section 37A, as I say, and that is when a court has been misled by misrepresentation or concealment of facts. So if a landlord comes along to a court and relying upon 31 F, G, A, B, C, whatever it might be, and it's shown to the court that there's been misrepresentation, then the tenant can claim damages from the landlord as resulting from that. In 42 years at bar, I've never been involved in a case where compensation has been sought under 37A. It's a rare case, but I put the provisions in the paper. Court procedures. This is where it really gets a little dry, but there it is, and unnecessarily complicated in my view. But there it is again. This is a landlord and tenant claim, so CPR 56 and the Practice Direction 56 applies. Go to that. The correct court is the county court. The High Court does have jurisdiction, but there are certain hoops that have to be jumped through in order to get to the High Court. Merely because there's lots of money involved is not enough. So again, I can't remember the last time, if I ever have, done a 54 Act case in the High Court. As this is an opposed application in our hypothetical case, CPR 7 procedural rules apply, and a landlord's claim form under Section 29(2) must contain certain particulars, again, which I set out in the paper, but I won't read them out now. The acknowledgement of service in the landlord's claim under Section 29(2), which is our case, is in Form N9. The defendant must plead in its defence whether it relies on Sections 23(1), 40, or 41, and if so, the basis of those. You remember those sections are where the tenant is a company and it's controlled by another company. The tenant is not a company, but is an individual. 41 is trusts. 41 is associated companies and 42 is trusts. Whether section 31A, and if so, what basis, and the terms of the new tenancy proposed in the event the landlord's claim fails. If the tenant makes the claim under section 24(1), again, N9 is the form of the acknowledgement service, and the landlord's defence must plead the grounds of opposition in full details, whether the landlord objects to the tenant's proposals, and if which he does oppose, what are his counter proposals, whether there's anybody else going to be affected by the grant of a new tenancy, or whether the tenant is required to take a new tenancy of the whole of the demised premises. As you will recall, the tenant is only entitled to a new tenancy of something called a holding. That's the part of the demised premises occupied for the tenant by the purpose of a business or by an employee employed in that business. But in order to prevent landlords being left with, for example, empty flats above lock-up shops, the landlord can insist that the tenant take a tenancy of the entirety of the demised premises, and it's if the landlord wants to do that, it has to say so in its defence. Evidence filed by the party as the court directs, with the landlord filing first. So that's an amendment to or a variation of Part 7. The landlord must file its evidence first, and that makes sense in a ground of opposition case, because the tenant will be able then to form a view whether the landlord's got a strong case or a weak case, and maybe avoid a trial at all. The tenant takes the view that it better just take its compensation and run. Unless the it's unreasonable to do so, grounds of opposition under section 31 are tried as a preliminary issue, and it's hard to imagine any common grounds upon which it would be unreasonable to do so. As CPRS 7 applies, allocation is required, but can never be a small track, so it would be a fast track on the multi-track. And if the court decides it's going to allocate to the one or other, it's got to have regard to the criteria set out in CPR 26.8, which I've listed in the notes. Most substantial 54 Act renewals will be determined under the multi-track. Level of judge, district judges and circuit judges have jurisdiction, but opposed applications will inevitably be listed before circuit judge. I can't remember ever having a district judge determine a 54 Act case. If allocated the fast track, the court will give directions for case management, set a timetable down to trial, all very neat and tidy. If multi-track, directions for a CMC or pre-trial review will be given, or other directions as see fit. Nothing unique about that. Unfortunately, applications for interim rent have their own discrete procedure, which is set out in paragraph 317 of the practice direction. Again, I won't deal with the details, but it's it does provide that the application can be made in the context of the current proceedings, or can take a form of a completely new claim if, for example, the application for an interim rent is not made until the application for a new tenancy has been disposed of. I can't imagine why one would leave it that late. Perhaps somebody forgotten that you can, but I don't know. But there is a discrete procedure, which I've disclaimed in the paper. Order: if the landlord succeeds on the preliminary issue, the court must make an order for the termination of the current tenancy in accordance with section 64. As I've said, that's 3 months and 21 days after. If the landlord fails, it must make an order for the grant of a new tenancy. But again, as I've touched upon, at the hearing of the preliminary issue, the parties won't be armed to fight over the terms of the new tenancy, and therefore more directions will be given for the determination of that. to be hived off to a later day. All that is certain is that the tenants will get a new tenancy of some kind. There's no special rules about costs in 54 Act renewal cases, and therefore the general rule under Part 44 applies. The unsuccessful will be ordered to pay the successful parties, but the court may make a different order. In a case where there's a trial of a preliminary point and the landlord succeeds, it's not too difficult to identify who the unsuccessful party is, and therefore, in such a case, the starting point is the landlord would get its costs, and the converse of that is also true. In the context of, well, I'll talk about unopposed cases in the second paper. I should mention this, that applications for new tenancies under the 54 Act, or an application by a landlord under section 29(2), are pending land actions and can be protected by a notice entered in a registered title, or a caution against first registration in the case of unregistered land. Sometimes that might prove to be wise to do, but I don't recall it being an habitual step that either landlords or tenants take. The danger is that if, for example, the landlord sells its reversion and the tenant has made an application on the 24(1), then the new landlord wouldn't be bound by all that's happened to date. So it may well be that that would be wise in a tenant's case. There's an awful lot of material there, and I've gone through it really rather rapidly, but as I say, I'm confident that the notes provide a full account of what the relevant practice and procedure is to which reference can be made. I'm now going to talk about unopposed applications, and same landlord, same tenant, same premises. And you see on the screen there the typical type of dispute. Both agree that the entirety of the demised premises should form the subject of the new grant. Tenant wants 10 years, landlord wants 15, that's the maximum. Tenant wants to pay 40,000 with no reviews. Landlord says 60,000 with only reviews. Landlord wants a break, exercise any time after 5 years if he wants to demolish or reconstruct. Other terms as the current lease. Tenant wants tenants only break clause after 5 years. The sort of issues that one sees in these cases. But again, the duty to provide information is one that arises in this context too. So if the landlord or the tenant wants to know more about what's going on, they can serve a new conservative notice under section 40 to that effect. The landlord's notice under section 25 has to have the same prescribed form. You just don't state that you're going to oppose the grant of a new tenancy, and there's no need to specify grounds of opposition because you're not opposing. It's expressly provided that unless the landlord specifies the terms that it is proposing for the new tenancy, the section 25 notice will not be effective. That's section 25(8). The tenant, as I said, needn't respond by any counter notice or any notification of that sort to the landlord once a section 25 notice has been served, provided one or other of the landlord or the tenant makes the application to the court under section 24(1. The tenant will be certain to achieve a tenancy of some kind. So that's all that the tenant needs to do. If the tenant makes an application for serves a section 26 request for a new tenancy, that which I've described in the previous paper will equally apply. The tenant's request is in a prescribed notice, a prescribed form, and it's the same whether the landlord is opposing or not. Indeed, if a tenant makes an application for a new tenancy under section 26, he might not know at the date when the request is made whether the landlord will oppose or not, and therefore prescribed form is the same in either case. And again, the Section 26 request has to be served at the times that we've discussed and must state what the tenant's proposals are for the new tenancy. When filling in the schedule to these notices with the proposals, don't forget, you've got to specify the property, the term, the rent, and the other terms of the tenancy. I've seen it so many times where it's just assumed that the property will be the demised premises, so nothing is said about the property to be included, and it gives an opportunity for one or other of the parties to go, Yahoo sucks, the Section 25 notice or the Section 26 request is not valid on that basis, which is a complete and utter waste of time and an issue that's so easily avoided. So just do what it says on the form. And as for other terms, it's sufficient to say as current lease with modern updating or words to that effect. Far better in my view, although it's easy for me to say, I don't have to do it, that if, for example, the tenant's making an application, serving a Section 26 request for them to append a draft lease to it, ditto with the landlord, and in an unopposed case with a Section 25 notice. So that would be in an ideal world. Applications to the court, again, Section 24(1) is the basis upon which the application is made, whether it's made by the landlord or the tenant in an unopposed case. And again, the application must be made within the statutory period, and the statutory period is the period that we've already discussed, namely the period ending on the dates of termination specified in the Section 25 notice or the Section 26 request, whichever the case may be. However, in the case where a Section 26 notice request has been given, the tenant can't make its application under Section 24 within the period of 2 months from the date on which the Section 26 request was served. That gives the landlord and the tenant 2 months to establish where they are in terms of the new tenancy, which will be granted, and save the cost of an application to the court under Section 24(1), which may not be necessary if the parties are able to reach agreement. Section 29B applies as well, so the statutory period can be extended by agreement. So if the 2 months the tenant has during which he can't make an application to the new court, the statutory period can be extended if they want to continue negotiating for more than 2 months. And as I say, that can go on as long as the parties wish. The application can be made for the termination of a new interim rent, in unopposed cases. And in those cases, the interim rent is determined in accordance with Section 24C. And the starting point is that the interim rent will be the same as the Section 34 rent. That means the interim rent will be the same as the rent payable under the new tenancy. So imagine in our case, the current tenancy would have come to an end on the 24th of March, 2024. The unopposed application is determined sometime in late 2024. The new tenancy commences, let's say, sometime at the beginning of 2025. Well, between the 24th of March 2024 and the beginning of the new tenancy, the rent payable by the tenant will be the Section 34 rent, namely the rent payable under the new tenancy. So that's all very straightforward. There are two sets of circumstances when the interim rent will not be that, and that where is the cases where the landlord or the tenant show to the satisfaction of the court that the interim rent determined, as I've just described, differs substantially from the relevant rent, or the terms of the new tenancy would result in a substantially different rent. again, since 2004, when these provisions were introduced, I've never come across a case where either the landlord or the tenant has relied upon that, bearing in mind that the terms of the new tenancy will reflect, for the most part, the terms of the old tenancy. But I've set out the rather complicated formula in 24C for calculating the interim rent in those exceptional cases. As for the court procedure, again, all that I've described in the first paper applies here. It's a CPR 56 and Practice Direction 56. The county court will be the court of choice. In the tenant's application under section 24, the correct defendant is the section 44 competent landlord, who may not be the immediate landlord. The section 44 and schedule 6 determines who the landlord is for the purposes of these proceedings, because remember that the person who is the landlord, sorry, put it this way around, the tenant is entitled to a new tenancy of the holding up to a maximum of 15 years. So the landlord must be that person with an interest in reversion, whose interest is sufficient for the landlord to grant a tenancy for 15 years. So if the tenant's immediate landlord is a tenant himself and its tenancy is 10 years to run, well, then clearly it can't make that grant. In those circumstances, the defendant in the tenant's claim is that person next up the line who has a sufficient interest to be able to grant a new lease of 15 years. Bearing in mind, it might not be 15 years, but the court has jurisdiction to order a new term of 15 years. As to the claim, this is an unopposed case, and therefore CPR 8 applies, but there's no requirement to file evidence with the claim form or with the acknowledgement of service. You'll remember under CPR Part 8, there's got to be affidavit or witness statement evidence with the claim form and a witness statement with the acknowledgement of service, but there's no requirement in unopposed 54 Act renewals for evidence to be filed with those court documents. This is the way that the rules are a bit complicated, because one has to jump around between 56, 8 and 7, and then 7 and 8 do not apply with in the same way as they do in ordinary Part 7 and Part 8 cases. The acknowledgement of service must be in form N210 and must contain certain information, as must the claim form. And I've set out in the notes what it is that the claim form must provide, and essentially what it is that is the main points are that the claim form must contain the tenant's proposals for the new tenancy. In the acknowledgement of service, the landlord must specify whether it objects to any of the terms proposed by the tenant, and if so, what they are and what his proposals are. And then it has to clarify whether it has a sufficient interest to grant a tenancy. That gives the heads up in case the tenant doesn't appreciate who the landlord should be for these purposes, and the name and address of anybody who the landlord believes will be impacted by the grant of a new tenancy. That could be somebody with a superior interest, or but in most cases, when you've simply got a landlord and a tenant, that's an idle ceremony. As I say, there's no requirement to file evidence unless and until the court so orders. Allocation. Unopposed application of the Part 8 is automatically treated as allocated to the multi-track, and therefore CPR 26 applies. Everything I said in the first paper about the level of the judge applies equally to unopposed cases, although perhaps I could see perhaps a district judge may feel pretty confident to be able to do an unopposed case. I don't know, that's just my speculation. The court will give directions for the management of the trial following receipt of the acknowledgement of service. As for the trial, as it's an unopposed application, the court must make an order for the grant of a new tenancy, and accordingly for the termination of the current tenancy immediately before the commencement of the new tenancy. As to the terms of the new tenancy, some can be agreed and some can be disputed. The usual battlegrounds are the term and the rent. Sometimes you have break clause issues, rent review provision issues. Rarely are there issues about the property to be comprised in the new tenancy. It's either the demise premises or the holding, as I've touched upon, and there's not normally great dispute about what the holding is. And if there's an issue as to what the holding is, it's for the court to decide by reference to the circumstances of the date on which it has to decide the case. The duration of the new tenancy can be anything the landlord and tenant agree, but the court only has jurisdiction to grant a new tenancy for 15 years, and it exercises that jurisdiction on the basis that the new term will be that which the court considers reasonable in all the circumstances. And one sees the debate between the tenant wanting flexibility and landlord wanting certainty. The terms of the current tenancy will often be determinative of how long the tenancy will be, the new tenancy will be. Of course, when the court makes the order for the grant of a new tenancy, it doesn't know when the current tenancy is going to come to an end. It knows that it will come to an end in 3 months and 21 days if the tenant doesn't appeal, but it doesn't know that at the date of making the order, even if, which should be done, the tenant were to, or the landlord were to ask for permission to appeal from the judge at first instance, and that permission was refused. So the manner in which that should be dealt with is to order a new tenancy ending on a date and commencing at the end of the current tenancy. So it'll be a tenancy commencing at the end of the current tenancy and determining on, and then a date that's specified. In that way, the tenant doesn't get a longer term merely because they've launched upon appeals. Because if the court wants to give a new tenancy for, say, 10 years, tenant might end up with a term of 11, effectively a tenant of 11 years if they appeal, and the appeal takes time. And I give an example of a recent case that went, 54 Act case that went to the Supreme Court, and not many of them do that. And it went on for, the decision of the Supreme Court was on the 5th of December 2018, and the Section 24(1) application was made in June 2015. So it's 3 years odd, arguing about that. So the order will be from when the date the tenancy comes to an end. The rent is determined in accordance with Section 34. Again, it can be agreed between the landlord and tenant or determined by the court under that provision. And essentially that's the market rent, having disregarded certain tenants' improvements. And that's not a matter of the court's discretion or what they think is reasonable. That's to be determined on valuation evidence. The other terms of the tenancy, other than duration rent, are agreed as between the landlord or the tenant, or determined by the court. And in so determining, the court must have regards to the terms of the current tenancy. What that means is that it's the burden, a legal and evidential burden of proof on any party who wishes to change the terms of the current tenancy to justify it. And not the paper to go into the law of that, but it's a case called Ome against City and London Properties, which House of Lords back in the early 80s, which addresses all of that. Very usefully, there's Section 36(2) allows the tenant to have a cooling off period. 14 days after an order for the grant of a new tenancy, the tenant can apply to the court for that order to be revoked. And so it doesn't have to take the new lease, because subject to this provision, the landlord is bound to grant and the tenant's bound to take the new lease. This allows the tenant, for example, to decide that the new rent that's been ordered is too high, or the other terms are not to its liking, and therefore it can it's not stuck with a tenancy that it doesn't want. That doesn't mean the tenant can just apply to the court and run off. It will be required, if it's agreed between the landlord and tenant or determined in the court, to remain in the premises under the current tenancy for a period reasonable opportunity, to provide the reasonable opportunity for the landlord to re-let or otherwise dispose of the premises. Because the landlord didn't oppose the application for a new tenant, he thought he was going to have a new tenancy, and then the tenant changes its mind, and therefore the tenant has to pay a price for that, giving the landlord an opportunity to re-let or dispose of the premises whilst receiving a rental income during that. Section 28 of the Act provides that the landlord and tenant under a 54 Act renewal can agree the entirety of the terms of a new tenancy to be granted in the future, and the current tenancy will come to an end immediately before the agreed commencement date of the new tenancy. Applications for interim rent, everything I've said in the first paper applies to that. And as for costs, again, no special rules apply. The only difficulty about costs in unopposed applications is that it's sometimes difficult to know who won and who didn't win. There used to be a rule that as the parties were coming along to the court and asking the court to knock their heads together and determine the terms of a new tenancy, the normal order should be no orders to costs, but in the 70s, Lord Denehan said that was wrong, and it's the usual rules that apply. But as I say, it's sometimes difficult to know who's won and who's lost. There's been a pilot scheme which is meant to run for a year, but it's still going in Central London County Court, where unopposed lease renewals are being transferred to the first tier tribunal. I'll send with the paper guidance on the operation of the scheme and the standard directions that apply in that case. I won't speak to them now. All that I said in the first paper about protecting an application as a pending land action apply here. Shortly after I finished preparing this paper, and well after I devised this scheme, the government policy paper Antisocial Behaviour Action Plan was published, and paraphrasing it in the way that I do, that apparently all the problems on the high street these days are down to the 54 Act, even though the title of the paper is Antisocial Behaviour. But what that means is that the Law Commissioner for Property, Family Law and Trusts has started a review. There'll be a consultation paper by the end of the year. That's what they say. Who knows when it will be produced. The Property Litigators Association have been canvassing members as to their views on the operation of the Act. So it may well be that all that we've been discussing in this today and in the previous and in the next paper will have to be looked at again, but it won't be any time soon. That's all I've got to say about the practice and procedure of the applications for new tenancy under the 54 Act. I repeat, the details will be in the paper to which you can make reference. They will be available to you in the next day or so. And I thank you again for attending and remind you that the next webinar is on the 4th of May at 3 p.m. And I'm going to be looking at the landlord's grounds of opposition in greater detail in that paper. Have a good afternoon, everyone.